Welcome to a new Border in Globalization podcast. Today, the main topic is the notion of jurisdiction, territorial jurisdiction, and extraterritorial jurisdiction. The notion of jurisdiction is very important to know the powers of the state that are limited in a territory and the powers of the state that are not limited by the borders of states. To better understand this notion of jurisdiction, this phenomenon of territoriality of power and extraterritoriality of power, we have the great pleasure and honor of welcoming Cedric Reingert, professor of public international law at Utrecht University in the Netherlands. Among other publications, he authored Jurisdiction in International Law in 2015 and a book entitled Selfless Intervention, the Exercise of Jurisdiction in the Common Interest in 2020. Welcome on board, Professor Reingert. Welcome, Cedric.
Thank you for having me.
This podcast today is divided into two parts. The first part focuses on the legal notion of jurisdiction and the sovereign state, and the second part will focus on the extraterritorial action of the states. Let's start our first part. International society is complex and composed in particular of sovereign states. The principle of sovereignty is at the center of the international order. Professor, can you remind us the importance of the category of territory and territorial sovereignty in today's international society?
Thank you for that question. Really, it is a very important question. World's legal order, world public order is fundamentally based on territory and on the notion of territorial sovereignty derived from territory. And this Westphalian concept of international law means that the world consists of states, and states are legal persons with a defined territory over which these states can exercise authority, sovereignty, and jurisdiction. So this also means that territorial borders, boundaries are crucial in international law as they are in international relations. And it explains also why we have territorial or maritime boundary treaties between states.
Thank you, Professor. Although the principle of territorial sovereignty builds the independence of the state on its own territory, several elements limit the exercise of the state sovereignty on its own territory. Could you tell us some words about the limitations to the territorial sovereignty of the state in its own territory, please?
Thanks for that question. So if you go back a bit in time, so in the past, states had absolute sovereignty over whatever happened on their territory, at least on paper. But even in the early days already, this was mitigated by doctrines of immunity and inviolability, doctrines which bar states from exercising their territorial jurisdiction to the fullest extent, bars them from exercising jurisdiction, notably over foreign states, foreign state officials, such as diplomat, for instance, the whole law of diplomatic immunity, or jurisdiction over foreign state assets was also decidedly limited. Now, since the Second World War, additional limitations have come about pertaining to international human rights law. States are not free to just violate the rights of individuals on their territory as they please. There is international supervision. There are international obligations binding on the states emerging from the minimum treatment of aliens from before the Second World War even. And obviously states can, generally speaking, always tie their own hands by entering into international agreements, treaties, limiting their sovereignty, for instance, in relation to environmental law, or entering into free trade treaties, for instance. And remember that in one of the earliest cases before the Permanent Court of International Justice, the so-called Wimbledon case, the court ruled, and I quote here from the ruling of the court, the right of entering into international engagements, and I would say engagements limiting your sovereignty, is an attribute of state sovereignty. So states exercising their sovereignty can decide to limit their sovereignty in relation to particular subject matters.
Nice. Thank you. We know that the sovereign state exercises its sovereignty within its territory. But what are the meanings of the term territoriality of the power of the state and the law of this state?
Well, to me, it seems that territoriality may not have an essence as such. It's a socially constructed term. And critical geographers have also pointed that out. It doesn't mean that the entirety of a set of relevant facts needs to take place on the state's territory for that state to validly exercise its authority. In fact, if we look at the practice of states, it may suffice that one element has some, oftentimes socially constructed, territorial link to that state, then grounding territorial jurisdiction. So we see that states sometimes claim territorial jurisdiction over a particular state of affairs, even if only a very weak territorial connection is present. And I'm thinking here of the US exercising jurisdiction in the field of sanctions, for instance, over foreign persons, foreign transactions denominated in US dollars. And to clear US dollars, you almost necessarily need a US correspondent bank account. And then the US claims constructed territorial jurisdiction over these economic transactions based on what the US and what US courts have called, well, there is an export of services from the territory of the United States. Or think of data, for instance, deterritorialized data stored on a server. A server is based somewhere territorially, based in a particular state, even if the user or the internet intermediary may be based elsewhere. And in principle, that server state may exercise territorial jurisdiction because the data can be said to be physically there where the server is. But the question then, of course, arises whether it makes sense to do this, as data are essentially deterritorialized pieces of information. So what I mean to say, it's all socially constructed. So you look for a territorial link of a particular set of facts, and then you exercise so-called territorial jurisdiction. But others might say, well, what you're doing is, for all intents and purposes, extraterritorial jurisdiction. So the dividing line between territoriality and extraterritoriality is very thin and sometimes even non-existent.
Wow, thank you, Professor, for this precision. In international law, the term jurisdiction goes beyond the simple competence of a court, as we know. But what does the term jurisdiction mean? Can you remind us, please, of the history of the word and its meaning?
Thanks for that question. Very briefly, perhaps. As you may guess, it's a Latin term, or I would rather say medieval Latin term. I don't think the Romans used it. But in medieval Latin, it's referred actually to stating the law, just etymologically speaking, uses law and dicere is to state the law, to lay down the law. So you could say, just based on this etymological analysis, it is a term that denotes the power of the authority of the state to lay down the law, to apply the law, and then also to enforce the law in relation to particular persons, objects, situations. And the state could mean the courts of the state, but it could also mean the political branches of the state, the legislative branch, or the executive branch, or law enforcement authorities, executive agencies acting on behalf of the state and exercising jurisdiction. But it is clearly related to the state jurisdiction. Perhaps later today, we can talk about whether it is a form of non-state actor or private authority or private jurisdiction that is exercised. But in the traditional view, only states exercise jurisdiction, or perhaps intergovernmental organizations which exercise state-like functions, like the European Union. The Court of Justice of the EU has said that the EU is also bound by the customary international law of jurisdiction. To just give you an example of jurisdiction going beyond the state in very limited circumstances, with a regional organization that almost looks like a state in terms of exercising competencies.
Thank you, Professor. The jurisdiction of a state, as we know, is linked primarily to its territory. It is known the international borders of a state mark the limits of its legal authority, but just a part of this legal authority. But international law also allows the exercise of the state beyond its own borders, and we spoke just a little bit about that. So, Professor, my question is this one. What are the links between the notion of jurisdiction and the border between states?
I think that goes back then to our discussion on territorial sovereignty. So the principle is that a state can exercise territorial jurisdiction over anything that happens on its territory, that is within its borders, basically. So that is really the link between jurisdiction and borders and boundaries or limitations, territorial limitations. So states cannot normally exercise their authority, their jurisdiction outside their borders. Now, that said, and we may discuss this later as well, in some situations, states can, are allowed even, to exercise jurisdiction outside their borders. For instance, in case the other state, which I would now call the territorial state, gives its consent, when the other state says, well, you can do it. You can enforce your jurisdiction on our territory. You can arrest a suspect, a fugitive from justice on our territory. So we basically then transfer the jurisdiction to you. But you would really need the consent of the other state. The international law is a consent-based system. Or in case, short of actual ad hoc consent, the state can rely on an accepted principle of extraterritorial jurisdiction, like nationality or security or universality. So we can discuss that later, perhaps, what that actually means. But these exceptions have come about over the centuries, especially in the 20th century, when the modern law of jurisdiction really came to fruition.
Thank you, Professor Reinert. The concept of state jurisdiction, as you said, has been much debated over time, particularly with modern international law. But what are the major theoretical debates on the nature of this state jurisdictions?
Yeah, so again, if you go back a bit in history, we should bear in mind that the modern notion of jurisdiction only came into being by the late 19th century, the early 20th century. And one of the key questions in the early days was whether states can, in principle, exercise jurisdiction as they please, unless there is a prohibitive rule to the contrary. So this is what we call jurisdictional liberalism as a theoretical angle to jurisdiction, or whether, and that's an alternative approach, instead states can in principle not exercise jurisdiction. So the point of departure would then be, no, you can't do it unless you can rely on a permissive rule allowing you to do so, like, of course, the territoriality principle or a number of accepted principles of extraterritorial jurisdiction. So that was an early debate, but somehow that debate has not fully settled yet. Although I would venture to say that the second theoretical approach is dominant these days, and that means that states have to rely on a permissive principle. For instance, territoriality. They would always have to cite a principle. They cannot just say, I can do whatever I want. No, they have to positively identify or justify an assertion based on one of the accepted principles which are, for that matter, quite flexible and malleable. So in the end, perhaps anything goes. We can discuss that later, whether the principles still serve as limiting rules, actually preventing jurisdictional overreach. So this has given rise then to another theoretical debate, right? What does it mean? What does territoriality, for instance, mean in a globalized world, the world that we find ourselves in today? Situations, facts have territorial links and sometimes tenuous links, as I already mentioned, with multiple states. So all these states could then potentially claim jurisdiction in a quasi-universal fashion. So everything becomes universal jurisdiction. So it becomes a jurisdictional free-for-all, if I can use that word. So this has then in turn sparked a quest for a proper understanding of the outer bounds of the jurisdictional principles like territoriality, and related a theoretical quest for a general rule underpinning and perhaps limiting the various principles of jurisdiction. And that general rule may perhaps be the requirement of genuine connection or nexus. This was put forward by the American Law Institute in the 2018 restatement of US foreign relations law as a requirement of unwritten customary international law. So jurisdiction would fundamentally, theoretically be based under international law on the requirement of a genuine connection. But then again, the question may arise, when exactly does a state have a genuine connection to a subject matter, allowing it to exercise your jurisdiction? So this actually shifts the problem from prescriptive principles of jurisdiction to genuine connection. At the same time, other notions have been suggested to limit overreach, resulting from a broad interpretation of the principles. And I'm thinking here of notions like prescriptive comity or the principle of jurisdictional reasonableness, a principle that I have written a lot about, but I think we need to admit that these notions may not be as such binding as a matter of international law.
Thank you, Professor Reingert, for this historical report. The relationship between the territoriality and the extraterritoriality has long been central to the theory of jurisdiction, and you just mentioned some important debates on it. Could you remind us, please, of the history of the territoriality, extraterritoriality couple or degrouping system between these two concepts, please?
So again, a bit of a history lesson, perhaps. So let's go back a bit in time to the dawn of the modern age, starting in the 16th century, when more certain, more definite territorial boundaries were drawn, and the modern states as we know them today emerged. Think of France, for instance, the first state, I would say, with clear boundaries at the time, mainly for tax purposes, that the boundary was delimited with other states. But then, of course, this whole idea of jurisdiction piggybacked on the drawing of boundaries. And then in theory, states had absolute and exclusive territorial jurisdiction over what happened within their boundaries. As I explained, that's the essence of the Westphalian system, the Treaty of Westphalia, 1648. But in reality, older forms of non-territorial and personal jurisdiction persisted, which allowed states to claim forms of extraterritorial jurisdiction over their nationals abroad based on a bond of political allegiance. So this is then extraterritorial nationality-based jurisdiction, which harks back to the time that people lived more in communities that were not necessarily territorially delimited, as sometimes there were nomadic groups and so on. So personal jurisdiction and territorial jurisdiction coexisted and still coexist. If you look at the late medieval time and also the early modern age, international traders, for instance, remained often subject to their own laws. This was called the lex mercatoria, still exists today, by the way. It's some kind of non-state law. They were subject to this law rather than to the territorial laws of any given state. So also in the modern age, territoriality was never as absolute as it was sometimes claimed. Now, if we fast forward to the 19th century then, Western states started to claim what is called extraterritorial consular jurisdiction over certain trade concessions in, at the time, weaker states such as China or the Ottoman Empire. And they did so on the basis of unequal treaties with those states. And then Western powers were allowed to exercise full prescriptive and enforcement jurisdiction and adjudicatory jurisdiction with respect to their traders in those foreign concessions. And I think in large part, this explains why extraterritoriality as a notion really got a bad name, a poor reputation, and was linked then to imperialist and colonialist endeavors. But these days, I would approach these concepts more in a neutral fashion, as just describing strong links to territoriality or to extraterritoriality. They coexist as notions, but again, as I already emphasized, we should be aware that at the end of the day, they are social constructs that could be manipulated by actors to achieve certain political or economic objectives. For instance, many claims of what looks at first sight extraterritoriality could in fact be reinterpreted and normally justified as simply a claim of territoriality. And as I've said earlier, states have relied on the principle of territorial jurisdiction as soon as just one element of a transaction has some territorial link, even if overall the transaction is essentially foreign and involving foreign persons. So this manipulation of territoriality is something that we often see in the law of jurisdiction.
Thank you, Professor, for the historical report on this complex history between the links between territoriality and extraterritoriality. And it's very important to understand, as you said, it is a social construct with a legal clause. The sphere of general law includes many specialties and very different branches of law. In this context, is it important to distinguish between civil law and criminal law, or public international law and private international law, to better understand the notion of international jurisdiction of the state?
Certainly, I think that's an important question. I'm myself a public international lawyer, and in public international law, we know jurisdictional principles like territoriality, nationality, security, or universal jurisdiction. And these principles have mainly developed in the criminal law, if you look at it from a historical perspective, mainly in the late 19th century. It's not exactly clear whether and to what extent these principles can be applied to other fields of the law. Perhaps they could be transposed to other fields of public law, such as sanctions law or antitrust law or securities, capital markets regulation. It's a form of administrative regulation, environmental law or taxation law. But even these fields have seen the development of quite specific jurisdictional principles, which are not necessarily known in the criminal law. To just give you one example, in antitrust law and competition law, We've seen the emergence of a principle of effects-based jurisdiction, which is grounded on the adverse territorial effects of a foreign antitrust conspiracy or a foreign merger. So this is quite peculiar to this field of antitrust law. It's not certain that this effects doctrine can also be applied elsewhere. Then civil or private law, as you mentioned, well, that field of the law basically boasts its own set of jurisdictional principles, and they're governed by the conflict of laws, private international law. Some of these principles resemble public international law principles like territoriality, but there are also principles that public international lawyers would not normally use, like the principle of domicile, for instance, registration, the principle of forum of necessity. So the point here is that whether or not a principle of jurisdiction is accepted may really depend on the field of law that we're talking about.
Exactly. Thank you, Professor. Let us now talk about the encounter between the classical notion of jurisdiction and globalization. And we spoke a little bit about that earlier. For instance, the cyberspace doesn't respect national borders, and many cyber crimes can be committed from anywhere. So my question is this one, Professor. How do globalization, processes, and digital technologies affect the traditional notions of jurisdiction and borders?
Well, it's clear that globalization, digitalization put especially the territoriality principle under pressure. If you look at globalization, for instance, it's clear that commercial ventures, activities are not just limited anymore to just one territorial state. And as a result, multiple states may have forms of jurisdiction, territorial jurisdiction over worldwide economic value or supply chains, acts of corruption involving multinational corporations. And one could then be concerned over overlapping concurrent jurisdictional conflicts between states, different states claiming jurisdiction. But in reality, there is sometimes a problem not of over enforcement, but a problem of under enforcement in case a particular set of facts does not have a very strong link with any state, and no international organization or international court has jurisdiction. So no state may feel the urge to exercise a jurisdiction. No state may think it has the responsibility to provide accountability here in case its interests are not directly at stake. Think about international crimes or piracy, to just give an example. As to digitalization, then, as I said, we face the problem here of the fundamental unterritoriality of data. Data can be moved from one jurisdiction to another in a split second, so there is no territorial essence anymore. Now, in theory, a state can exercise its territorial jurisdiction based on the fact that a computer is located in its territory or that data is located on a server in its territory, but often states will not really know whether that is the case. So this is what we call loss of knowledge of location, which is really prevalent in the cyber domain. And in that case, it is argued that any state with an interest or a connection could, and that doesn't have to be a territorial connection for that matter, so just any connection, if it's sufficiently strong, substantial, could perhaps exercise jurisdiction over data, so regardless of any territorial nexus.
Thank you, Professor. Some authors speak about economic war to mean sanctions, trade restrictions, and tariffs. Can we talk about an instrumentalization of the notion of jurisdiction to serve the interest of state powers in a kind of economic war?
Well, again, jurisdiction is said to be a form of political technology. And as I already pointed out, principles of jurisdiction could be manipulated to serve predefined political ends. And this politicization of the notion of jurisdiction, or instrumentalization, as you also called it, can notably be successful if a state has substantial political and economic leverage over other states or operators based in other states. And I'm here talking about states that control the so-called nodes of global governance, especially economic choke points like supply chains, the global financial system, or global ICT infrastructure. So states could then claim territorial jurisdiction over transactions involving a globally dominant currency. Think of the US with its dollar dominance. Or they could claim territorial jurisdiction over any goods entering their market, thereby setting the rules for how goods are produced abroad. So think about the huge consumer market of the European Union, which allows the EU to possibly set rules for the world. So this is the so-called Brussels effect.
Thank you, Professor. We have reached the end of the first part of the podcast.